The Mitigation of Mark Sievers, Till Death Do Us Part, an in-depth book on the mind of Mr. Sievers, available at your Amazon bookstore. So what happened with the $4.5 million life insurance policies that Mark Sievers had on his wife now that he was convicted and found guilty of murder? We're going to have a special guest on our show, Alain Roman, who is an estate planning attorney expert, and he's going to take you in depth of what will happen to that money and how you can plan for your future. Welcome to Gotham Investigations. I'm your host, Jeff Giordano. We're talking about the Mark Sievers case today, a case that rocked Bonita Springs, a case that was a murder for hire, and his wife, a well-known holistic doctor who had her own TV show as well, was murdered and hammered to death. So part of the trial, they had their estate planning attorney had to testify on a trust account that was put together along with a will. So we have a special guest on our show today, and he's a very well-known estate planning attorney, and that is Alain Roman. Alain, welcome to our show.
Thank you for having me, Jeffrey.
So Alain, during this case, their attorney that they had, their estate planning attorney, had to testify. And part of that testimony, which I kind of thought was a little strange, was the attorney was a female, and she went up there, and she says that Teresa Sievers had over $2 million of life insurance policies that was in the trust, but separate from the trust, she also had a couple other $1 million, and she thought that she should have actually had more life insurance policies of what she was worth. Now, we're talking about a middle-class family, not a wealthy family. Is this common for a middle-class family to set up a trust account in such insurance policies on such high amounts? And one of the things that the investigators looked at when they questioned Mark Sievers in this case is he said there were $2.5 million of life insurance policies when actually they found out it was over $4 million. So that kind of created the motive and increased it even more. So our question is, how do you set up a trust account? And what are the legalities behind it? Just because you're a beneficiary doesn't mean you have to follow some state regulations and guidelines to get that money. So there are some provisions in place that you just don't get that money right away. Can you explain if somebody wants to set up this account? And first, what is your website and what can people do to hire you for your services if they need them?
Okay, thank you for your question, Jeffrey. Let's try to break that question down into a couple of pieces, right? If somebody wants to reach me, they can always find me. I'm the only attorney in Florida with my name. So if you search Alain Roman, you're gonna be able to find my website. I'm number 1 on Google, so that should come up. It's alainromanlaw.com. But let's go back to that question, because that question can actually be broken down in a few different pieces. First, the estate planning attorney testifying in the case. Usually in Florida, we have something called the Slayer statute. So it means that if you murder or kill somebody with intent and you're found guilty, the surviving spouse gets certain protections. Because in an event like what happened in the Sievers case, the wife died first.
Correct.
The wife died first, meaning that the husband survived. That means that the husband, for example, may have been a beneficiary in a lot of those accounts. So that's the purpose of the Slayer statute, to say, look, the reason why she died was because of you. That means that we're not going to give you the benefit of just being able to collect the life insurance. So we're going to treat you like you have died before your wife.
Okay, that's very interesting, because the attorney actually testified that she set the trust account up for Teresa, and then she had to set up the same exact trust account for him. And from the beginning, when they were looking at Mark Sievers as a possible suspect, the Department of Children and Families actually filed a petition to take the children out of his custody. And they did not have enough proof to say that the kids were in danger other than he was a potential suspect. So the judge at that time ruled in favor of Mark, saying basically, yes, you can say that this could probably happen, this can probably happen, but at the long run, it's a probability, it's not fact. So the Department of Children and Family were actually a little upset that the police department wasn't showing their exact hand on evidence, and they lost that fight. But in the long run, that was a wrong judgment that the judge made, because this individual could have committed suicide and killed his kids at the same time. So tell us a little bit about trust accounts and how they work.
Yeah, so trust, you can set up a trust in two different ways. You can set up a trust while you're alive, or you can set up a trust in your will to be created after you pass away. Most people create what is called a revocable living trust. The revocable living trust can be changed by the person creating the trust, what we call the grantor, at any point prior to death. After death, that trust becomes irrevocable and no longer can be changed. Some people, especially the people with higher net worth, may think about creating something called an irrevocable trust, meaning they set it up, it's very hard to change, or it shouldn't be changed. And usually the reasons to create an irrevocable trust, for example, is mainly for asset protection purposes, to get it basically out of your name, to protect it against any lawsuits. And the second reason is for tax purposes, because as you know, at least in the year 2023 where we're now, the state tax exemption is a little bit over $12 million, meaning that if your net worth is less than 12 million, you don't pay any state taxes. But if your net worth is more than 12 million, then you're paying state tax, and the tax is actually pretty high. It's almost 40%. It's 40% of everything over 12 million. So it's very important for people that are wealthier to maybe create an irrevocable trust and do other estate planning techniques. But to set up a trust is pretty simple. You go to a estate planning attorney like myself. We'll write up the trust based on the provisions that you want for when you're alive, and also for after you pass away, because the trust protects you not only for death, but it also protects you in the event of an incapacity, to have somebody in place to manage your assets if you were not able to manage them yourself. And once you create a trust, basically you go to your bank of choice, or depending if you have real estate, for example, then you will retitle those assets to create them in the name of the trust.
Now, what does something like that cost, more or less, to set up? And can you put your properties and company and businesses under that trust as well?
You can pretty much put any asset under a trust. The only assets that is usually not recommended to put into a trust is your individual retirement account. You cannot retitle your individual retirement account. You can definitely put the trust as a beneficiary of your IRA, your individual retirement account. There are particular rules that you have to follow, especially after death, and they can get quite complicated, especially after some changes that happened with the Secure Act in 2019. However, that is possible, but any asset that you can think of can go into a trust.
Now, in this particular case, you had Teresa Sievers' sister at the beginning when she gave interviews with the police, saying that it's impossible for Mark to be involved in this. And then her story changed drastically when she found out about all these life insurance accounts. So what ended up happening in this case is the attorneys on this case, they were banking on a not guilty plea, because then, of course, they would have a better fight to get that life insurance money. Attorneys would get their fees. So these attorneys had to take out like massive loans, because pretty much a trial of this magnitude and significance, it really takes up all your time as a law firm. So in this particular instance, the sister filed for custody of the kids. So upon conviction, she was got custody of those children, and she was kind of named of the trust, but the kids were going to get the money, but she was able to get like a better living, a house for these children and herself. How does that work if you're not named in the trust? How can you be like a beneficiary of the kids and still be able to pull money from that account for these children?
Of course. There's two aspects that you have to think about. Number one, if both parents are deceased, or in this case, the wife, the mother, had passed away, then the father potentially got convicted and he went to jail. So if the kids are minor, they're gonna need a custodian. So a parent can file a petition in court, in family court, because there's two courts that you can potentially get help with. Number one is family court. A family member can petition for a temporary custody, meaning that the court is willing to give a parent that petitions the court, look, give me custody of the child, and if that is granted, then the parent is gonna be able to, or that family member is gonna be able to basically have the right to enroll the kids in school, make medical decisions, and whatnot. The second aspect, which probably happened in this case, is that the family member that took custody of the kids had to get a guardianship. And the purpose of the guardianship is that every parent, mother and father, naturally in Florida, or legally, is the natural guardian of the person. When I say guardian of the person, let me explain a little bit more, is that there's two types of guardianships in Florida. It's guardianship of the person and guardianship of the property. So the guardian of the person makes a decision of where the child's supposed to go to school, who's gonna make medical decisions, who should surround the child, like friends, socially, the right to travel, and all the rights of the person. Naturally, parents are that guardian. They don't need to go and get a guardianship to do that, like the law already gives them that right. Now, guardian of the property is the person that's supposed to manage property, be able to sign contracts. A child is not an adult, doesn't have legal capacity until they turn 18 years old. Meaning that if a child in Florida, for example, receives more than $15,000 in an inheritance or a life insurance policy, for example, then a guardianship of the property needs to be appointed. And the purpose of that is so that the court can keep accountings of what the child is getting, the money the child is getting, how the money is being used for his behalf and for his benefit. So that's likely what happened here. So that although there may be a trust, or the trust sometimes has protections for the child, it would name a representative basically to receive accountings and receive reports from the trustee that is administering the trust to make sure that everything is being done properly.
So the children, just so our viewers know, at the time of the homicide, were two daughters, 11 years old and 5 years old. So we've handled cases and we conducted private investigations for trust accounts before, and usually it entails a guardian of litium, if you can explain to us what that is. And before they could release funds for, say, a private investigator or for even an attorney to sell properties and stuff like that it has, they have to go in front of a judge and they have to request, like we currently have one now that they're requesting 24 hours of security as well as a private investigation into, I really can't say for client privilege purposes, that what it's about. But they have to first go in front of a judge, explain to the judge, we need to pull money from this trust account. This particular case, the individual is still alive. Can you explain to us what a guardian litium is and what they have to do to get money to do, like, say, an investigation or other things outside the trust to get that money?
So usually the court would appoint a guardian. It's a court-appointed guardian that the court appoints. It's usually an impartial attorney that has knowledge on the case, on the legality of the issue that is going on. And they're just trying to make sure that whatever money or whatever the child is getting is in the best benefit of the child. That the price that is being paid for is accurate, is reasonable, but the utmost importance is that anything that's being done is for the benefit of the child. So that guardian has to file a report with the court and letting the judge know, Judge, this is what happens. This is what they're trying to do. We review the contracts, we review the attorney's fees, we review everything about it, and we feel that under the circumstances, under the facts of the case, this is reasonable. it's like a third hand for the court to have somebody there to make sure that the child itself is represented. It could be that whether the child is gonna get money or something is gonna happen for the benefit of the child, but obviously the child cannot consent. So that's why you need that guardian ad litem.
So could this also happen, say you have an elderly parent and you slowly see their health, declining. Do you recommend a power of attorney, and can you explain to us what a power of attorney is? And is it possible for somebody to be a guardian of lithium to an elderly person who's like healthy, but suddenly their health is declining?
That's actually a great question. In Florida, we want to avoid having guardianships as much as possible. We always want to try to find the least restrictive alternative to having to appoint a guardian. Because once you appoint a guardian, for the most part, the person is declared incapacitated. When somebody gets declared incapacitated, certain rights, like I was explaining before, being the guardian of the person, the guardian of the property, get removed. For example, if somebody has a plenary guardianship, what we call a total guardianship, where all the rights get removed, meaning that that person no longer has those inner rights that we get through the Constitution of Florida and that we get as a person. Some of those rights are the right to vote, right to travel, right to marry, right to enter into contracts to decide for our own medical decisions, the right to, basically, the court strips you down. They just remove all your rights, and it's for your protection. Because if the court finds you incapacitated based on the evidence, based on the reports of the doctors, because reports are done, examinations are done to make sure that this person is incapacitated. Courts in Florida are very strict with these incapacity cases to make sure that the rights of the person are protected. Usually somebody that's declared incapacitated also gets appointed an attorney to make sure that the rights are also protected. But we don't want to go through all of that if we don't have to. If the person has capacity to sign a power of attorney, then that's the first thing we always want to try. Obviously, sometimes it's a little bit difficult for a client that's elderly and may have dementia, Alzheimer's. And the reason is that you have to sign that power of attorney when the person has capacity, meaning that the person may have dementia, but if they can have a lucid moment, then that power of attorney can be signed. The issue becomes when that person has a lot of money or may have a lot of assets, and there's kids or there's other people in place that want to, quote unquote, take control. Because what I've seen in my practice is that when the person has a lot of money, obviously the family member is very involved. They want to make sure that mom or dad are taken care of. But when there's no money, it's really hard to get somebody like to show up and and take care of mom and dad or take care of grandma, grandpa. But if they can sign, meaning they have a lucid moment, if they have dementia or Alzheimer's, but as long as they can sign, it's just a mental state. It's not a physical state. They can, they might not be good physically, but as long as they're good mentally, we'll sign a power of attorney. The other option is you can do a voluntary guardianship where you don't lose your rights. You just say, court, hey, look, I feel like I'm getting weak, old, and I need help. I want a voluntary guardian to be appointed. And it's a similar process to appointing a guardian. However, you don't lose your rights because you're not declared incapacitated.
Now, how does a person find out about a will or a trust? Like, suppose we have a lot of cases that we do investigations, and they're like, oh, I live in Wisconsin, Kansas City. My uncle died in Miami. My grandfather died, and they always says that I'm part of the will, but now, the black sheep of the family came in. The son, like you're saying, that was never involved before, doesn't want to give us privy of what, my grandfather was leaving in the will. Is there any way to obtain that information, or you just have to go with the word now of the black sheep of the family that comes in and says, no, you're not in the will?
Yeah, so in Florida, if there is a will, the custodian of the will, the person holding the will, is supposed to turn it into court within 10 days of the person's passing. That usually does not get enforced because obviously somebody passes away, you still have to do the funeral, You have to get death certificates in order to open up a probate to begin the process. So that does not necessarily get enforced unless somebody is not producing the document. So we want to use that statute to say, look, you have a duty to present that will within 10 days. There are some registries online that people can report their will. Usually a will or a trust is a private document, meaning that you don't have to record it in public records, because once you record it or once you submit it into court, it becomes public records, and now everybody knows what your will says, or they might have access to your assets depending how specific your will is. But the recommendation for most folks is that once they create their will or they create their trust, they don't necessarily have to give out copies, but they should definitely tell family members that it exists and where they can find it. That's usually what I tell my clients. Look, if you pass away, I need somebody to be able to find out that you had a will. Obviously, I always keep a copy for my clients, but they need to, somebody in the family needs to know where they can find your will.
So you keep a copy of a will, you hear somebody passes away. Is there certain steps that you take as an attorney, or you just wait for the family to contact you and distribute funds on that?
So if there's somebody has a will, I will always keep a copy. I give the original back to the client. Some attorneys will keep the original. I try not to keep the originals because it's a big responsibility. And also, what happens if I die or if my office burns or whatever, I'd rather have the client is the most protection that they're gonna have is having the client hold the original. However, if they lose it, that's what the purpose of the copy is, meaning that we can always produce a copy later on to say that, look, they just lost it, or they were never able to find it, but they never had the intent to revoke it. So yes, I have to wait for a family member to reach out to me. Usually a will nominates a personal representative, and that person nominated will actually be my client. That will be the person in charge to going through the probate, doing the whole administration. In Florida, you have a right to select your own attorney. Usually us as attorneys, we cannot solicit, so we have to wait for that person to contact us. Most of the time, the family does contact the attorney that prepared the will, especially if there's a relationship, because that attorney already has a picture of everything that happened, the family dynamics. It's smart to contact the attorney that prepared the will, but you don't necessarily have to.
So does it work like pretty much like life insurance policies, where you have the beneficiaries, and if nobody comes forward, the insurance company has to reach out and try to locate these people and make at least an attempt to find these individuals before they just kind of leave the money in limbo? Is there anything with these wills that I'm a son of somebody that makes a lot of money and they're wealthy, and I don't want my nephew to find out what's being left here? What is in place to protect that from happening?
Yeah. So when you introduce the will always gets introduced into court. It's a process called probate. And in that process, obviously the will is going to have the beneficiaries. It may not have the addresses. It may not have how to contact these people. So what usually happens in a case like that, the personal representative, that person nominated, has a duty to do a diligent search, meaning try to find the beneficiaries. Look in the mail, look in the postal service to see if they have an address, try to find them online, maybe even hire somebody like you to try to find them. If that does not work, then that personal representative can appoint a guardian ad litem to represent the beneficiary, because the beneficiaries have rights in the probate process. They have to sign certain consents, especially if a property is going to be sold. So a court may appoint a guardian ad litem to represent that beneficiary that cannot be found. And even if they cannot be found, after you finish the probate, and what the court usually does is that they'll put the money in the court's registry for the benefit of that person. And after a while, if the person can no longer be found, then there's things that you can do in Florida, like the family could file a petition for presumption of death. Maybe the person has been missing for more than 5 years, and the death at that point can be presumed, because it's a statute in Florida if you've been missing for 5 years. And there's no reasonable explanation as to where you went, and you search for them, you produce evidence that the person was found or last seen in a parking lot, or the person used drugs or alcohol, and there may be a propensity that the person had passed away. So those are things that usually happen in those type of cases.
So this is a case that Mark Sievers and his wife Teresa were swingers, bringing in a whole bunch of outsiders. Where it was even presumed that the police chief was in the swinging capacity and wanted to take them down before the word got out. The probate attorney, she may have even been involved in the swinging lifestyle, which was kind of odd for her to take a stance for the defense team and talk so great about Teresa Sievers, but her purpose was to say she thought there should have been even more life insurance policies in place to try to help out the defense team. Now, let's say the opposite were to happen and the prosecution was to get the attorney that plans the estate to testify. Does attorney-client privilege protect it from her testifying if she says, no, I'm not going to testify? Or is she demanded to drop that client privilege and testify in a case like this?
That's actually an interesting question. The question becomes whether that person officially became a client for that attorney, whether the person believed that she was your attorney and an attorney-client relationship was formed. There are certain exceptions to the attorney-client privilege that an attorney can basically apply, especially, for example, if the attorney is accused of wrongdoing and the only way to exonerate his or herself is to share client information, then there are certain safe ways. And I believe there's 3 exceptions to the attorney-client privilege. Obviously, I'm not in the need of using them every day, and I don't know them exactly by memory, but I know that one is one for sure. Or I believe that if my memory recollects me correctly, also if the client is going to commit a crime, could also be an attorney-client confidentiality exception as to when you can actually share client confidentiality. But most of other cases, the attorney-client confidentiality in Florida is pretty strong. It's there for a reason, to be able to have people come to attorneys, speak out their mind, and have that conversation privileged.
Now you had mentioned previously, in a case like this, they would declare Mark Sievers deceased before Teresa and bypass the money. A true story that happened when I was a police officer with the city of Miami. There was a sergeant named Ben D'Amico, and he was retired. He just retired, and he was like a week or two into his retirement. And what happened, him and his wife, they both had kids from different marriages. The kids and family were always at a feud with each other. Obviously, Ben, being a sergeant, he had a good pension. He had a house, and he had a lot of property. So the agreement he made with his wife was, if I die, you're going to get the money, and you take care of my kids, and you take care of your kids. And on the other hand, if she died, he would get the money, and they promised each other, I would take care of your kids, and you would take care of my kids. Now, the kids were always at war. So what happened in this case, they were going to a motorcycle convention in Wisconsin. They were traveling, I believe, through Iowa or one of those states along the way, hit by a semi-truck. Both of them died and were deceased on the scene. But because of fire rescue, they declared him dead, and they declared her dead a minute or two after. So in court, what happened was all the money went to her accordingly because he died a minute before her. So now, in her will, her kids were going to get the money. They never planned on dying like this together. Can you elaborate on that? And obviously the kids were fighting because they hated the kids on his side, and they wanted to keep the house, they wanted to keep the money. How important of this is to kind of see an unforeseeable future, and how can you prevent something like this from happening?
Unfortunately, those things do happen because I have dealt with cases like that before and with very similar facts. Not that case that you're mentioning, but very similar facts. All you need to prove, Jeff, that somebody survived, all you have to do is take one breath more than the other person to have survived in Florida. I tell people, because people think all the time that, oh, what if we died in a car accident together? What if we died? And I tell them, yes, you may die in a car accident together, but 99% probability is that you will never die at the same time, meaning instantly. Both die, time of death is the same. It's very, very rare. The only way that I really seen it is maybe a plane crash, because there's really no evidence as to who really died first. And because obviously most people don't survive, so you cannot produce any evidence. But in most other cases, you can always prove who died first. And usually in Florida, we have a presumption of death, meaning that if we do not have enough sufficient evidence to who died first, everything gets split like 50-50. But in a case like this, obviously there was a minute or two difference, so that's why everything went to the other. In cases like that, it's very difficult because once a spouse predeceases, then the dynamics are whether they have a will or do not have a will. Because usually in a case like that, when you have a mixed family, the surviving spouse, the one that survived by a minute, will get 50% in that situation of the estate, and the other 50% will pass to the children of the person that passed away. Now, if there's a will, like you were mentioning, and if the will says everything to my spouse, then everything goes to the spouse. And then we have to take a look at the will of the spouse that survived to see whether it says that everything goes to their kids. At that point, somebody is getting screwed. Some family is getting screwed. Some kids are getting screwed. That's why I always tell people, if you have a mixed marriage, mixed family, meaning that all the kids are not from the same mom and dad, you definitely need to have a estate plan. Because what happens most of the time, Jeff, most blue-collar families, they own what? Their home. They necessarily do not have multiple properties, investment properties, or they might. But if they're married, they're buying it as husband and wife. When husband or wife passes, automatically that property goes to the survivor. Survivor can control 100% of the property when they die. They can give it to their kids. They have no duty, no obligation to give it to the spouse's kids that passed away first. So it's important to create a estate plan, and at that point you might even involve a family attorney to write up a prenup, postnup, or do some type of planning. But if you don't do anything, one of the kids' family is going to get screwed. It is usually the person that dies first.
So, Align, just to wrap things up, we have a lot of listeners out there. The majority of our listeners are common, everyday families, interested in crime podcasts. A lot of them are attorneys that follow. They try to follow our investigations, see what kind of conclusions we come up with. But a lot of them also are really sick, demented individuals out there that listen to our podcast as well. So we have a sick, demented individual out there listening to our podcast, and he's planning a murder of his family, of his wife and kids. What should he set up in a trust or account or a will to protect himself and not have what happened to Mark Sievers? Is there a way that money can go into an account and he can maybe still be authorized to tap into that from, say, jail if he was arrested, or appoint somebody he wants to from there? What could this individual do to prevent what happened to Mark Sievers and losing that money, and the attorney from losing that money? Not to say that we want to help these sick, demented people out there.
First of all, he should
definitely
not tell that to the attorney, because the attorney, like I said before, may have a duty to report that person. So, and hopefully as an attorney, I would not want to be put in that situation. It's a pretty hard situation to be put as an attorney. We have rules and ethics in place as attorneys with the Florida Bar to protect us and to protect the community. But let me try to answer that question because it might be a little bit more complicated. Definitely cannot be, if you have a revocable trust, Jeffrey, the revocable trust is treated as you owning the property. What usually happens in a case like that is that not only will you have, and this is more an asset protection comment than anything else. When you have a revocable trust, and in that case, you may have a criminal case, but you probably are also going to have a civil case. The family of the person that passed away is going to file, most likely than not, a wrongful death lawsuit. And in the wrongful death, if the property is in a revocable trust, it can definitely be tapped into to collect any judgment that the family may or may not win. Now, could you place that trust, for example, in an irrevocable trust to make it harder for the family to get it? You could probably do so. However, I would see a core inequity not allowing you to use the law to shield you against having criminal intent or based on the facts that you were saying. Definitely, obviously, I need to do a little bit more research and to give a quick disclosure. This is not legal advice, okay? You should always consult your attorney and ask questions, and everything is specific to your facts. So I hope you take all of this as educational, and we're not creating an attorney-client relationship. There we go. We had to throw that out.
Elaine, tell us a little bit about your background. I understand you also have an accounting degree. You have a fascinating legal background, which a lot of people out there, our listeners, don't know. But just explain a little bit about your background history, your degrees, and your goals in life as an attorney.
Of course.
I know one of your goals is to have a law firm and just sit back and direct everyone what to do, because you mentioned that several times. So we're going to help you reach that goal.
I love being a business owner. Definitely, I own my own law firm. It's hard between being a business owner and an attorney, because you are an attorney all the time. I am an attorney while I'm here. I'm an attorney while I'm with my friends. I have to be honest. I have to be ethical in everything I do. Those are the rules that are promulgated by the Florida Bar. And obviously, you always want to be an ethical person in anything you do in life. I graduated in 2015. I graduated from St. Thomas School of Law. Graduated second in my class. I think we had about 175 people. I took some tax courses in law school. I fell in love with tax. So after that, I applied to NYU. NYU is the top law school in the world for the master's in tax, what we call an LLM. So I got accepted, and I told myself, if I get approved, I get accepted to go, I'm just gonna pack everything and I'm gonna go to New York for a year. So that's what I did. I went to New York for a year, got my LLM in tax. Then I came back. I worked for a couple of firms. First doing international tax, then doing more domestic estate planning for high net worth individual. And then at some point I told myself, look, my dream is to be a business owner, to be my own attorney. I'm gonna open up my firm. And I did that in 2018. I've been by myself all this time, luckily growing every year, and we're hope to keep growing in the future. But I can do the estate planning for the blue collar person, mom or dad, or I can help out people a little bit more wealth that need more of the tax planning.
Now, Elaine, you read our book, The Mitigation of Mark Sievers, Till Death Do Us Part, and you also put a great acknowledgement on the back cover, which we certainly appreciate, that as well. Just what were your thoughts looking at it from your legal perspective as far as a estate planning attorney?
As an estate planning attorney, I'm always thinking, what's going to happen with the kids, the life insurances? Maybe these people think that the life insurance might be available, but obviously they might not know of this layer statute, like I mentioned earlier, that may treat you as having predeceased. But mainly, I think the saddest part is for the kids that, one parent passed away, the other one's now in jail on the death penalty. Now they're stranded with maybe a family member they're close to or not close to. But what happens if there's no family members? What happens if this is a poor family and there's nobody really to take care of them? Now they fall into foster home. Now they fall into the webs of Department of Children and Family. Try to help these kids in some type of way, and it's very difficult for a child that loses their parents to be able to grow up in a system or in a way that allows them to flourish. So for me, taking care of these kids is the biggest concern that I had while I was reading the book.
So, Alain, I know you mentioned that your name is unique. I've known you for a while now. We've also worked some cases together. But there's a lot of gringos out there. And gringo like myself, it was like today till I finally freaking started pronouncing your name correctly. Can you just spell out your name for some of these gringo listeners if they want to find you? Because they won't know how to spell it or how to look you up.
Of course. The first name is spelled Alain. That's Alain. And the last name is Roman. The last name is pretty easy, like the Roman emperors. So if you search Alain Roman, I'm pretty sure something similar to that, I'm pretty sure I will come up.
There you go, and there you have it. Alain Roman, one of the best in the business, estate planning attorneys. Thanks for listening, and stay tuned for our next episode.
Thank you, Jeffrey.
Are you a fan of our show? Do you like our show? Then comment, hit the like button, and subscribe, or you might be the next one we investigate.